Laws, Regulations, Transportation, Establishment, Chapter 7. Learning Objectives. Identify the law affecting the transportation sectors. Identify the rights of the passengers of commercial transportation. Explain the relevance of the law to the promotion of the tourism in the country. Laws on Common Carrier. The law. Articles 1732. Common carriers are persons, corporation, firms, or association engaged in the business of carrying or transporting passengers or goods or both, by land, water, air, or for compensation offering their services to the public. The above article makes no distinction between one whose principal business activity is the carrying of persons or goods or both, and one who does such carrying only as ancillary activity. In local idiom, as a sideline, Article 1732 also carefully avoids making any distinction between a person or enterprise offering transportation services on a regular or scheduled basis and one offering such service on an occasional, episodic, or unscheduled basis. Neither does Article 1732 distinguish between a carrier offering its services to the general public, the general community or population, and one who offers services or solicits business only from a narrow segment of the general population. 1733. Common carriers, from the nature of their business and for reasons of public policy, are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passenger transported by them, according to all circumstances of each cases. Article 1733. Notwithstanding, common carriers are exempt from liability for loss, destructions, or deterioration of the goods due to any of the following causes: flood, storm, earthquakes, lightning, or other natural disaster or calamity; act of the public enemy in war, whether international or civil; act or omission of the shipper or owner of the goods; the character of the goods or defects in the packaging or in the containers; and order or act of the competent public authority. Article 1755. A common carrier is bound to carry the passenger safely as far as human care and foresight can provide, using the utmost diligence of very cautious persons with due regard for all the circumstances. By contract of carriage, the carrier assumes the express obligation to transport the passenger to his destination safely and observe extraordinary diligence with a due regard for all the circumstances, and any injury that might be suffered by the passenger is right away attributable to the fault or negligence of the carrier. Example: carrier to prove that it has exercised extraordinary diligence as prescribed in Article 1733 and 1755 of the Civil Code. Article 1756. In case of death or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observed extraordinary diligence as prescribed in Articles 1733 and 1755. Clearly, the trial court is not required to make an express finding of the common carrier's fault or negligence. Even the mere proof of injury relieves the passengers from establishing the fault or negligence of the carrier or its employees. The presumption of negligence appeals so long as there is evidence showing that a contract exists between the passenger and the common carrier, and the injury or death took place during the existence of such contract. In such event, the burden shifts to the common carrier to prove its observance of extraordinary diligence and that an unforeseen event of force majeure had caused the injury. Article 1757. The responsibility of a common carrier for the safety of passengers as required in Article 1733 and 1755 cannot be dispensed with or lessened by stipulation, by the posting notices, by statement on tickets, or otherwise. There are times when passenger is transported for free or is in gratis arrangement. Here, a stipulation on the limitation of liability of the common carrier to less than extraordinary diligence is valid, but not for the willful acts or gross negligence. Article 1759. Common carriers are liable for the death or injuries to passengers through the negligence or willful acts of the former's employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. This liability of the common carriers does not cease upon the proof that they exercise all the diligence of a good father of a family in the selection and supervision of their employees. Nature of airline, bus, and shipping tickets. The law. The best evidence of a contract of carriage is the passage ticket. Under our jurisprudence, an airline, bus, or shipping ticket is a contract of adhesion considering that all the provisions thereof are prepared and drafted only by the carrier. The only participation left of the other party is to affix his signature thereto. In such situation, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the safe, in this case the carrier. Seatbelt Law. The seatbelt law was enacted to secure and safeguard its citizenry, particularly the passengers and drivers of private and public motor vehicles, from the ruinous and extremely injurious effects of the vehicular accidents, in order to secure the safety of the passengers and drivers at all times. The mandatory enforcement of the use of seatbelt devices by the drivers and front seat passengers of private and public motor vehicles shall be enforced. Registration of aircraft. Only aircraft owned by or leased to citizens of the Philippines and which are not registered under the laws of any foreign country may be eligible for registrations. Law on Transportation of Animals. By the virtue of Republic Act 8485, also known as the Animal Welfare Act of 1998, it shall be the duty of any operator of any land, air, or water public utility transporting pets, wildlife, and all other animals to provide in all cases adequate, clean, and sanitary facilities for the safe conveyance and delivery thereof to their consigns at the place of confinement. Public Service Law. Public service includes every person who may own, operate, manage, or control in the Philippines for hire or compensations with general or limited clientele, whether permanent, occasional, or accidental, and done for general business purposes, any common carrier, railroad or street railway, traction railway, subway motor vehicle, steamboat or steamship line, ferries and watercraft, and shipyard.